Now joining us, a constitutional law expert, Attorney Jennifer Reyes. Hi, Attorney. Thanks for joining us again. It's nice to see you.
Hi, good morning to everyone, and thank you for inviting me to your show again.
All right, Attorney, let's get right to it. Now, in simple terms, why do you think the Supreme Court found the impeachment process as interpreted by the lower house for VP Sara's complaint as unconstitutional?
Well, first off, the Supreme Court, in its latest decision, ruled that since the first impeachment complaint against VP Sara Duterte on December 24, 2025, was not included in the order of business and referred to the proper committee within the constitutional periods mandated. Hence, it's already triggered the one-year bar rule under the 1987 Constitution. This means that the fourth impeachment complaint, which was transmitted to the Senate during that time, was already invalid or unconstitutional because it means that it is already a second impeachment complaint within a period of 1 year, which is exactly prohibited by the Constitution.
So in other words, Attorney, the interpretation of session days or while in session was a crucial part of the Supreme Court's decision-making process.
Yes, you are correct, Mr. Diego. In this latest Supreme Court ruling, it stated that for the purpose, because it's a general rule when we say session days, right, of the House, it means that from the time it is called to order until the session is adjourned, regardless of the passage of time. However, here, the Supreme Court clarified that for purposes of including an impeachment complaint in the order of business within 10 session days and referring it to the proper committee or the Committee on Justice within 3 session days thereafter, when we say session day, it should mean a calendar day where the House holds a session or a plenary session for that matter.
Right. But, Attorney, don't you think that when the Supreme Court redefined the meaning of a session days, and is this not dictating the precise timing and method by which the House must, interpret their own rules? Kumbaga, ito po ba ay yung sinasabi nilang judicial overreach?
A beautiful question and a tough question. But in my humble legal opinion, yes, I believe that it is quite a judicial overreach since the House of Representatives must have been given a wide range of discretion or a certain leeway to interpret or how to interpret its own internal rules. However, since the Supreme Court in interpreting the Constitution must be complied with, or its decisions must be complied with. Although, of course, I believe in this famous saying that you can criticize the people or the one whom you revere, right? So in my humble opinion, it is a judicial overreach, but at the end of the day, everyone, including the highest officials of the country, must comply with the Supreme Court's resolution.
Right.
So moving forward, does this now make a valid impeachment complaint more difficult to file rather than those that are being filed just for the sake of immunity?
Yes, that is a great point, because the Supreme Court laid very detailed guidelines as to the procedures which must be complied with before an impeachment complaint can be initiated before the House of Representatives and before it can be transmitted to the Senate. The impeachment process now becomes quite complicated. But on the positive side, this recent resolution of the Supreme Court, since it gave or spelled out the exact guidelines, then the House and the Senate now has a benchmark or a certain guide so as not to repeat this kind of being rendered unconstitutional, meaning the articles of impeachment they initiated or they transmitted will no longer be considered as unconstitutional because they now have guidelines which they can follow and must comply.
Attorney, it's interesting you mentioned the word benchmark and guidelines. Does this mean that let's take into consideration the Senate, the archive complaint? Does it mean that they have their own leeway to decide whether to accept the Supreme Court's decision or not based on the guidelines they have received, or do they have to follow this?
They have to follow this. Just like what I mentioned, the Supreme Court as the, well, of course, interpreting the Constitution is mainly a judicial function. And now that the Supreme Court has spoken, it spelled out the guidelines. The Senate, even if it is a co-equal branch of government, and the House of Representatives, for that matter, they must still comply with the said decision because we are not talking about the supremacy of the Supreme Court. We are now talking about the supremacy of the Constitution, which the Supreme Court construed or interpreted.
Well, last point on that, but a lot of people have been saying that regarding the Senate, we have to remember that it will be put to a vote, if ever, and merely the senators will be guided only by the ruling, but not necessarily their votes will have to be patterned after the Supreme Court's ruling. So at the end of the day, it's still going to be a political exercise.
Yes. The Constitution merely mandates that 2/3 vote, right? 2/3 vote of the senators will be sufficient to remove or oust an impeachable official. With respect to that, the Senate has the sole discretion on that. The Judicial Department or even the Supreme Court cannot dictate as to the voting of these said senators.
Yeah. All right. So the question here also is that did the Supreme Court act as the guardian of our Constitution or as a co-legislator in terms of redefining itong 10 session days? And with that as well, since we are talking about internal rules of the House of Representatives, meron din po bang possibility that the House of Representatives could redefine or reword their process, their procedure in the House since sa kanila naman ito?
Regarding your first question, I believe the Supreme Court, of course, in good faith, wanted to interpret the Constitution or to guard the Constitution. But just like what I mentioned a while ago, in my humble opinion, it is quite a judicial overreach, right? And as to your second question, whether the House can reword or redefine their internal rules, yes, they, of course, have the freedom to reword or redefine their own rules of impeachment. However, they must be guided or they must comply with the guidelines set forth by the Supreme Court in their decision. They must be in accordance with the guidelines ruled by the Supreme Court in this case. They cannot contravene the said ruling.
But having said that, what happens now to the previous or old cases that were guided by the old rulings, yung Francisco versus House of Representatives, diba? Kasi sabi nga nila, affected lahat ng mga rulings na yan because of this recent ruling ng Supreme Court.
With respect to the previous impeachment complaints filed against VP Sara Duterte because of this recent development, then they are dismissed already. They can no longer be, discussed again legally. Right. However, it is worthy to emphasize, and our kababayans must listen to this, that in the Supreme Court decision, on page 2, page 7, and page 45 of their decision, the Supreme Court underscored that they are not absolving VP Sara Duterte of any charges against her.
Right.
Meaning, the House can still initiate an impeachment complaint against VP Sara Duterte on February 6, 2026 and onward. So this decision is not an impediment. It is not an obstruction for the House to again file a new impeachment complaint against VP Duterte.
You're right, but I'm talking about all the cases, the old ones.
Precedents.
Na yung mga precedents, yung mga sinundan ang House, ba yung Francisco versus House of Representative na ruling that, because di ba, for the longest time, yun yung sinusundan ng House of Representatives. Only that this ruling yesterday na nabago yun.
Oh, okay. Because in the decision, the Supreme Court likewise mentioned that the petitioners were invoking the doctrine of operative facts. All right? Because under the doctrine of operative facts, if you will declare a certain law or a governmental act unconstitutional, there are certain effects of that law before it was declared unconstitutional, which cannot be nullified. However, in this case, the Supreme Court also clarified that the doctrine of operative facts cannot be invoked at all instances. This can only be invoked if the nullification of the effects of the law which was declared unconstitutional will result to inequity or injustice. Moreover, it stated that parties who are responsible for the non-compliance of the rules cannot invoke the doctrine of operative fact. Only those parties who acted in good faith.
So,
Yeah. No, but the question here is now, Attorney, regarding the question a while ago about the lower house rewriting the rules, can they rewrite the rules in gray area in such a way that it skirts the gray areas of the previous rulings, and they could test the Supreme Court once again and have a new precedent?
For me, that is an unwise move if they will do that, because it will result again in further delays. Then it will become a dilemma to the effect that no impeachment complaint will, be pursued in the future just because they will be adamant or they will insist their own rules or they will redefine their rules again. So the wise move here for me is just to comply with what the Supreme Court stated as guidelines. They can pattern their new rules on impeachment on the said guidelines so that they will no longer, or the articles of impeachment they will later on file, will no longer be attacked with respect to its constitutionality or validity.
And also for the benefit of our viewers, what happens now to impeachment complaints against one certain official that could be days apart? What does the House need to do now in terms of consolidation? In effect, if there's a stronger complaint that will follow a weaker complaint, can the House wait and consolidate both instead to avoid the immunity being triggered by the weaker complaint?
Well, the consolidating of impeachment complaints, the Supreme Court already stated that it is within the discretion of the House of Representatives whether or not to consolidate several impeachment complaints. Also, it emphasized that there is no particular hierarchy with respect to the impeachment complaint which must be prioritized by the House. Even if the impeachment complaint was filed by a private citizen, or even if the complaint was filed by at least 1/3 of the House of Representatives, there is no hierarchy. It can even consolidate the two if it wants to, as long as it will comply with the constitutional periods. For example, a first impeachment complaint was filed and it is sufficient in form and substance, and it was included in the order of business within 10 session days, and it was referred to the Committee on Justice within 3 session days thereafter. That completed process, it will now trigger the 1-year bar rule, meaning no additional impeachment complaints can be filed against the same impeachable official within that same year.
Of course, we are talking about the longer way of filing the impeachment
Longer
complaint.
mode.
The longer mode, Pero it's also different when somebody filed it through the easier mode, which is yung endorsed by 1/3 of the House of Representatives. Tama po?
Yes, that is correct, darling. And also, just as a reminder to our, congressmen and congresswomen, if it will be filed, if the impeachment complaint will be initiated by at least one-third of the House of Representatives, please take note that you need to give a copy of the said articles of impeachment with the attached evidence to all the members of the House during the plenary wherein you will file the said impeachment complaint, because the Supreme Court stated that it is not only those one-third House members which has the power to initiate an impeachment complaint. It is the whole House. So as a matter of courtesy, and also as a matter of informing the constituents of all the House members, then all the House members must be given a copy of the articles of impeachment draft and the evidence appended thereto.
Now, Attorney, with regard to the issue naman ng impeachment complaint against the President, do you think this is on the right path as within the ruling of the Supreme Court?
Well, I believe, if I'm not mistaken, they have stated that since the first impeachment complaint was already included in the order of business and referred to the Committee on Justice, then it already triggered the one-year bar rule. So let us see if this impeachment complaint will, undergo the proper process before the House. Will they comply with the guidelines crystallized by the Supreme Court in its latest decision, and will it be transmitted to the Senate so that trial shall forthwith proceed? But of course, if the House deems it insufficient in form and in substance, they have all the right to dismiss the said impeachment complaint.
Right. Very well said. Maraming salamat po sa inyong oras, constitutional law expert, attorney Jennifer Reyes. Thank you for joining us.